All righty, Mabel. Third day of appeal in the name of Breeze and TSB Bank PLC.
My Lord, I said yesterday I was going to address you about the mechanics of the SVR, and I was going to make 2 points about the standard variable rate as defined under the general conditions. First of all, to identify what is the SVR, in particular following a transfer to a new lender. And the second point is how that new lender can vary the SVR. So turning to the first
Before you
point.
get into the detail, I'll ask you this question. As we were discussing yesterday, it's common ground that under the conditions, Northern Rock had an unrestricted right of transfer. The condition 19.1 refers to the possibility of various rights being transferred, something which I think you place some reliance upon. How do we know what rights were transferred to TSB?
Well, my Lord, the first point is that this appeal concerns the right to set interest and vary interest, and we know, in answer to your question, that clause 19.1 transferred that right.
Well, do we? How do we know that? Because 19.1 empowers Northern Rock to transfer that right, but how do we know that it actually was transferred?
Well, my Lord, I think that isn't disputed, that the loan that was made, the mortgage and the together loan made under the general conditions was transferred to TSB upon the sale by Northern Rock to the various lenders, including TSB. And I'm just...
Well, sorry, I'm not sure I'm understanding this. And I'm sure it's wonderful. And it may be helpful if we just look at 19.1 just for a moment in a convenient place.
Yes, my Lord. Before you do, I was just looking though at the agreed statement of facts,
Right.
because that might...
Well,
yes.
Can we look at 19.1 first, and then that may provide the answer.
Yes.
The agreed statement of facts may provide the answer to my question.
Yes.
What I'm referring to, as I'm sure you appreciate, is that the first sentence of 19.1 is permissive. It says, we take it at the stage of Northern Rock, we may transfer or charge or otherwise dispose of the offer or any of our rights under the offer, including the right to set interest rate to any person.
Yes.
So, in principle, some rights could be transferred to A and other rights could be transferred to B, or indeed, some rights could be retained. All of those possibilities are encompassed by that wording.
Indeed, my Lord, but my answer to that would be that there is no suggestion that there has been a transfer of anything other than the complete mortgage package to TSB.
So your answer to my question is all rights were transferred.
Indeed, and
Your
that is...
statement of agreed fact says acquired legal title.
Indeed, that was the point I was going to make. And indeed, Northern Rock was dormant by this stage, so it's not suggested that Northern Rock retained any rights, and I'll come on to my Lord Justice Newey's point in that regard later. But it's not suggested that anybody else had the right, and that is not part of the facts before you. The facts before you are that TSB has stepped into the position of Northern Rock and acquired the mortgages. And the question is not before you that the rights have somehow been retained. It is, the question is, upon transfer of the offer, what is the lender's right to vary the interest rate, essentially has become the new argument. But that's on the assumption not that some right has been retained by somebody else.
Mr. Saul told us that I think there have been requests for disclosure about the details of the deal. But that's what he said, wasn't it?
So
So the terms on which title was transferred have not yet been disclosed, is that right?
that is right, but my lord, just to be clear about this, because a point was taken about this, neither party suggested disclosure of any such agreement was relevant to the preliminary issues at the time of the CCMC. So the parties didn't seek disclosure, and it wasn't ordered by the court or covered by the statement of agreed facts pursuant to which the parties agreed that these issues would be determined. And just to be clear, preliminary issue 1 was agreed by the claimants. There was a dispute over preliminary issue 3, which we succeeded on, but there was no dispute by the claimants that preliminary issue 1 should be determined, nor that it said that anything should be ordered in response in order to cover it. Shortly before trial, the claimant's solicitors made a request for the transfer agreements without suggesting that they were relevant to the PIs, and the possibility of their disclosure was floated at trial but not pursued by the claimants because they were not relevant. And there's been no suggestion by the claimants in the many months between the judgment and this appeal that such documents might be relevant.
So are we to proceed on the basis that the statement of agreed facts assertion statement that you acquired legal title to the claimant's mortgages means that you acquired all the rights
Indeed.
covered by the first sentence of paragraph 19.1?
And it's not been suggested to the contrary in any of the argument by my learned friend. And the premise of the claimant's pleaded case is that TSB did and does have the right to set interest.
And just relating all this to what you were saying a moment ago, you say acquired legal title to the mortgages in terms of 19.1 is acquired the offers.
Indeed. And what I would say, my lord, in answer to my Lord Justice Arnold's question, it would have been incumbent on my learned friends to suggest that any rights were retained in order to mount that argument, but that's not their case. Their case is we do have the right to set interest, and pursuant to the express terms, that right is to be construed as subject to various restraints. And they say that arises from their language, and in particular, as I'll come on to say, they rely on the use of we, our, etc., and the use of the word standard. So they're looking at the text to say those restraints arise on the express terms, not because we didn't acquire certain rights.
Thank you.
So may I just go back to the definition of standard variable rate in the mortgage offer general conditions? And if we continue to look at the 2005 conditions, that's at the supplementary bundle tab 9, please. And the definition is on page 155, the first page of the tab. And my lord, if you just focus first on the first sentence, that means such rate as we from time to time decide to set as the base from which to calculate interest on our variable rate mortgage loans. Now, the first word, without wishing to state the obvious, is standard variable rate, using the capitalised term, is said to mean something. So it's a defined term. And may I make in that context 4 points, please? First, as my Lord Justice Newey observed yesterday, that rate as defined in the contractual terms is a numerical rate of interest. And so at any given time, the current standard variable rate, which you see appearing in the next sentence on line 3, the current standard variable rate that applies to this mortgage is a specific numerical rate. And we know that at the time TSB acquired the Whistletree mortgages, the standard variable rate as defined was 4.79%. And you take that from the agreed facts of paragraph 12, which is at tab 7 of the supplemental bundle. And it's important, my lord, because the interest charged on the mortgage is determined by reference to the numerical standard variable rate. So if one looks in tab 12 of this bundle at the mortgage offer, and it's page 187, please, you will see that the interest, if one looks in the box in headed tab number 4, and it's 4 bullet points down, the variable rate, a variable rate which is guaranteed to be below the Northern Rock standard variable rate, which is currently. The variable rate here, the standard variable rate, has to be a number so the parties can determine whether the interest rate on this specific mortgage is or is not below it. Pausing there, may I pick up my learned friend's reliance on the word prevailing? And this was in various places yesterday, but particularly if you'll note at day 1 of the transcript, page 59, lines 16 to 20. If you could please go back to the definition of standard variable rate at page 155, tab 9. You'll see that prevailing is no part of this definition. It appears, going back to the offer letter.
To be sure, but that's the whole point of the submission, because he relies on condition 22 and says, well, the offer, to the extent that there's any consistency, prevails. Trumps what's in the general conditions. So it's precisely because it's not in the definition that he seeks to rely upon the offer.
But if we look now at the offer, we see how it's used. So if we go, please, to tab 10, page 170. You see, for example, in 12A, in the last sentence, at the time during the rate periods, our prevailing standard variable rate may be lower. Now, the ordinary meaning of prevailing means the rate applicable at any given time. It's the rate that prevails at the time. And it's clear that the offer letters are using the word prevailing in precisely that ordinary sense. So when you look at the text that I've just shown you, this is plainly talking about an SVR that will be set in the future, on the expiry of the special rate period in the future. So prevailing here means the rate that will be the SVR at that time. So upon the SVR that will expire at the end of the special rate period. My learned friend not only seeks to suggest there's a trumping, but really his submission is that prevailing means something different. He says prevailing means pre-existing, and then uses that to say that's how you colour the definition of standard variable rate in the conditions. But that's wrong, because when you look at how it's used, it can't mean pre-existing, and it's not the ordinary meaning of the word. Now, the second point that my learned friend relied on is that he tried to place the weight on the word standard and use that in when he was referring to standard variable rate. And it was he tried to suggest that this meant somehow that the rate had to apply across the board. Now, it's not clear what across the board means, but my learned friend equivocated when my Lord Justice Arnold asked him whether he accepted that the reference to standard variable rate is to the defined term in the general conditions. And that was at day 1, page 81, lines 21 and following. but it must be, the word here, standard, is referring to the defined term. And the point can be illustrated by looking at the different conditions and the different offer letters.
Can I just be clear? When you say here, where do you mean? Which reference to standard have you got in mind?
I think he is using the word where he says standard variable rate. He's placing emphasis on the word standard.
Thing is, we get that capitalised or we get it uncapitalised. Where it's capitalised, it on the face of it just refers to the definition. But on the other hand, if you look in 19.1, it's not capitalised at the end, and that may have more significance.
Yes, and I'll come on to that point, which is separate. But here, as I understand my learned friend's case, it's the word standard as it appears in the offer letters. So, for example, page 170, as I'm showing you, that he places emphasis on.
Well, certainly my question yesterday was directed to texts such as this.
Exactly, that's where it appeared.
Where it is capitalised.
Indeed.
And there on the face of it, it's the defined term.
Exactly, but my learned friend's case is that standard has a meaning beyond the defined term, and he didn't accept my learned Lord Justice Arnold's point. I don't think he denied it either, but it wasn't accepted. And I was just going to show you that you can be sure that the references, the capitalised, and I'll come back to my Lord Justice Newey's point, the capitalised references on which he places emphasis are to a defined term because the way the term is used in the different offer letters mirrors the different terminology and the different conditions. So to give you an example of this, in the 2001 conditions, the defined term was called standard variable mortgage base rate. And you see that in the supplementary bundle, so the same bundle you have open at tab 5, and it's at page 117. You see there's a definition just before the heading 2. Whereas, as you've seen, the 2005 conditions and the 2004 conditions use the defined term standard variable rate. And so if we could then just look at...
The definition is the same, is it?
It is.
Word
It's-
for word.
And it's what has been, it was agreed in the agreed facts that there is no material difference between the 2001 conditions and the 2005, including this definition.
Yeah, but just to sort of nail this point down insofar as we can, I mean, you're right to point out that difference in the term that's defined, and one can see in the earliest of the offer letters that we've been shown, which I believe is tab 7.
That's right.
Because that's 14th April 2004. And one sees on page 143, the introductory paragraph, it says many of the terms used in this document are defined or explained in that booklet, which is referring back to the general conditions that you've just shown us. And consistently with that, which I'm sure is the point we're going to make, in condition 10 on page 145, we see reference at the foot of the page to our prevailing standard variable mortgage base rate.
Exactly.
So that's tolerably clear, but the one we were looking at earlier, I was struggling to find the bit where it says the terms are as defined in the general conditions. And maybe there, I just couldn't see it.
So can I just show you first, my lord, just to make good the point that you just made. So you're absolutely right, that was the point I was going to make. And I just want to make good that if you look at the bundle at tab 6, what you'll see is that you see addition 2 at the top, and that's November 2004. And that's the first time we see standard variable rates used rather than, and you see that the offer letter you just looked at predated edition 2. And then you have further offer letters, as you say, in tab 10 and tab 11 and tab 12 onwards. And your lordship was saying that you couldn't see the reference back to the conditions, I think.
Well, specifically, the statement, the terms are defined in the conditions.
But as you say, there is a more general point. Where in that offer letter does it refer to the conditions?
My lord, I'm just looking through that. As again, as I understand it, and this may not be a comprehensive answer, there is no dispute that and in fact it's part of my learned friend's case, that the offer goes with the relevant conditions, and I assume they were packaged together. There is no dispute about that for the purposes of the preliminary issues, and indeed his case is that they're read together. But we'll check if there's any equivalent language. I can't see the exact same language, so my Lord or Justice Arnold's right about that, but I don't think there's a dispute that they go together. And of course it's using the defined terminology. And of course the conditions themselves refer to the offer. And it may be that the difference in the new conditions, edition 3, for example, at tab 9 that we're looking at, defines the offer, as you see, means the offer of loans in which these general conditions are incorporated, and includes the conditions set out in that offer. As your lordship had that at page 155.
Yeah, but it's one thing for it to be common ground if general conditions are incorporated into the offer, and therefore the two documents have to be construed together. That, as you rightly say, I don't understand in dispute. But it's a slightly different point as to whether terms that one finds in the offer letter are defined in the general conditions.
Well, I think so, my lord, because if we look at the general conditions, which obviously have changed their form to this extent, if you look at page 155, in these general conditions and in the offer, and the offer is then defined in the general conditions as the offer of loan in which these general conditions are incorporated and include the conditions set out in that offer. And the two are hand in hand, because it says in these general conditions and in the offer, the words in bolds below have the following special meaning. These words may not appear in bold elsewhere. So it's saying that the conditions are defining the words in the offer as well, and that includes standard variable rate.
Thank you.
And just for completeness, the agreed statement of facts at paragraph 5 says the terms of the claimant's mortgage contracts are contained in the mortgage offer that incorporated the version of the general conditions that was in force at the relevant time. That's tab on page 4 of that bundle. So what we can see, just rounding up that point, is where the term in the offer letter is used, standard variable rate or standard variable mortgage base rate, it is a defined term when it's capitalised, and therefore one can't place the emphasis upon the word standard as having some form of more different generalised meaning that is one of my learned friend's textual arguments. The third point...
I'll just take you back to the prevailing point. Forgive me, out of turn. What precisely do you say prevailing or prevail means?
The rate that it was in force at the time, the current rate prevailing at that time.
At what time?
At the time to time, and in the offer letter, it is upon the expiry of the special rate period, and then the rate that was then standard variable rate would be applied,
Prevailing at the relevant time.
prevailing at the relevant time.
Thank you.
And just by contrast, my learned friend's argument is prevailing means pre-existing rate.
At what time does he say that? You understand?
As I understand it, is it was originally as at the time of acquisition of the portfolio, and subsequently as at the time of any variation being made, that it had to be the application of a pre-existing rate. But if you see it's how it's used, the word is used in the offer letters, that doesn't make sense. And it's not the ordinary meaning of the word anyway. My lord, going back to my third point on the definition of SVR as defined, it is determined from time to time by the person referred to by the words we and our. So the definition, to remind you, is at page 155 at tab 9. We and our are defined in condition 1.1 to mean Northern Rock PLC and any person to whom we transfer the offer under condition 19. So depending on the context, we and our can refer either to Northern Rock or to TSB as transferee or to both of them.
Does it refer to both?
So if TSB retained the SVR set by Northern Rock, that would be our SVR, and it would have been Northern Rock's SVR and TSB's SVR.
But then it would have to be Northern Rock that changed that rate, wouldn't it? I mean, if you were simply adopting the Northern Rock, you were saying we're going by the Northern Rock rate. It would be the Northern Rock rate as set from time to time by Northern Rock.
Well, it would be either because Northern Rock is within the definition of our, relying on the use of the word and in the definition of our, or because by retaining the SVR upon acquisition, the SVR became the SVR set by TSB for those mortgages. So all I'm saying is our can be a reference to both in different contexts.
I can see it can be, you can refer to either in
Exactly.
in a different context.
But it can't be simultaneous.
It's hard to see how it can be simultaneous.
But I say that that's the word our can encompass both of them,
Yes,
because but it not necessarily simultaneously.
yes.
And that the reason that's important, if you remember, is that my learned friend relies on our as meaning exclusively TSB upon transfer, and therefore it can't be the rate of Northern Rock. The fourth point is that
Well, that wasn't quite how I understood the point, which is, but it's close. So I think it's not so much our as we. So I think, sorry, I'm looking at the wrong set of conditions. So let me get the right set of conditions. For this purpose. So in the definition, the argument as I understood it is that when it says we may change this rate from time to time under condition 7 or the offer, the argument is that means Northern Rock. And it then goes on to say if we dispose of, transfer or dispose of the offer, that's still Northern Rock, so the argument goes, a person to whom we make the transfer may change the rate to its own base rate, and that's referring to the transferee, i.e. in our case, TSB. That's how I understood the argument.
So I think that's some of it, my lord. The first point they make in their skeleton argument relies on the word our, variable rate mortgage loans, in the definition of standard variable rate, and that's at paragraph 14.1a and 24.2 of their skeleton. And they say it must mean a pre-existing portfolio of loans at the time of transfer, because they could, transferee couldn't salami slice. And on that basis, it said that the 4.79 rate TSB inherited doesn't satisfy the definition of standard variable rate. So I think that's the argument.
Isn't that a slightly different argument? So I thought we were looking at the definition of standard variable rate. And you're right that that argument is that you've just articulated is certainly advanced, but that's a I mean, and of course, from the claimant's perspective, all roads lead to Rome. But I thought we were focusing here just purely on the definition of SVR.
I am. I think those words appear in it's our variable rate mortgage loans. That's their argument. I was making the point, my lord, that as we set from time to time.
Sorry, I maybe I've misunderstood then. So that's the wording in the second line of the definition.
Exactly. So I think there are several points that come from the language, and I was making the point that such rate as we from time to time decide to set in the interest in our variable mortgage loans, disregarding the restrictions, and we then looked at the definitions, and I was saying that we could or our could refer to Northern Rock and anyone, or TSB, or both of them simultaneously. That's how I introduced the point. And my learned Lord Justice Newey said, how does it refer to both? And I was saying, well, it doesn't necessarily simultaneously, but it can encompass both. The word our isn't just limited to TSB.
So if TSB were to transfer them on again,
Yes.
then in the definition of standard variable rate on 155, the we would apply to TSB.
That's right. And the transferee lender. So, and then, my lord, I think based on the claimant's skeleton, they don't accept the word our can be referring to both Northern Rock and TSB as the context requires. Their skeleton is that our variable mortgage loans must mean TSB pre-existing loans, and they also rely on the same language in the offer letters, and I'll come on to address those in more detail. And then the other argument they refer to on the language is in the conditions at 7.2, that they say our own funders in 7.2b must mean TSB's funders, and that requires a pre-existing rate to be adopted. So, as I understand their case, they're trying to read down the word our in any context as only to TSB, and therefore excluding Northern Rock as at all times. And I was simply saying that's not right. And the judge quite rightly found that was not the right construction.
I mean, however you look at it, pre-transfer, it can't be the right construction.
No,
I mean,
that's right. Pre-transfer is, but we're not talking about pre-transfer.
No,
but it's
but
got
pre-transfer, it's got to be Northern Rock.
Exactly. And post-transfer, it will be TSB as the context requires, but there can be references to both in different contexts, is the point. And that is what the judge held.
Can you give an example of where it means both? Is there an example where it means both at the same time?
No, I don't think so. I think it's just within, I think what's being said by my learned friend is the word our can't include Northern Rock within the definition once TSB has taken the transfer. And I was saying that Northern Rock is within the definition of our, relying on the use of the word and in the definition. And it could also include TSB. So our SVR can be Northern Rock's
deeply
SVR.
puzzled by this because I don't understand why this is necessary for your argument.
It's not necessarily my argument. I'm trying to address the argument, my lord, that's...
I mean, I thought your case was straightforward,
It is.
namely that we and our are both defined to mean Northern Rock and
Exactly.
successor.
Exactly.
And as soon as there's a transfer, the successor steps seamlessly into Northern Rock's shoes and
That's
has all
right.
the same rights.
That's right. That is our case. It's my learned friend's case that the use of the word our can only mean one or the other, and therefore he reads all the conditions as meaning, for example, when there's a reference to funding.
I'm sorry, but we're talking about the extent to which it can at any one time encompass both. And I thought it was Mr. Soul's argument that it encompasses both. Because on his reading of the definition, in the early part, after a transfer, nevertheless, the early parts of the definition continue to refer to Northern Rock, whereas later parts of the definition it's referring to TSB. So I thought it was his case that it has the dual meaning simultaneously, not yours.
It's my case that the word our can encompass both, and therefore TSB doesn't have to apply an pre-existing rate in order to comply with the conditions. It's my learned friend's case that if in order to read the conditions literally, you have to say that TSB sets its own rate, otherwise the conditions don't work. But I can show you the argument specifically. The fourth point, I'll come back to that point, my lord. We set as the base, the standard variable rate is the rate we set as the base from which to calculate interest, capitalised interest. And interest is a capitalised defined term, and we see that it's defined to mean the interest we charge under condition 6 of the general conditions at the interest rate. And the interest rate is defined just below as the rate of interest charged under the offer. So it follows that the standard variable rate is the rate used as the base from which to calculate interest for under the mortgage offers that are subject to these general conditions. And the reason I make that point is that the definition of standard variable rate cannot refer to other rates used by Northern Rock or TSB in the context of their diverse banking businesses, including other mortgages governed by different terms, because such other rates are not the base from which TSB sets interest with a capitalised I under the general conditions.
I'm not sure I do follow this.
So interest is defined to mean the interest we charge under condition 6, my lord, at the interest rate. And interest rate means the rate or rates of interest we charge under the offer, which is capitalised, and that's defined as well. So interest as defined is what is being charged, my lord, under the general conditions on these mortgages. It's not referring to TSB's various other rates.
But do you not just end up back in the definition of standard variable rate, and then we look at what that means? And then you have to worry about what the base is from which to calculate interest on our variable rate mortgage loans. So I'm not sure why any of the rest of this adds anything.
Well, only because I think my learned friend is trying to read this as applying to imposing an obligation to apply a pre-existing rate. And our point is interest as defined is what's in these terms, not any other rate applied to any other portfolio.
And that I don't really, I can't quite see why these extra terms add to that argument or assist. So we see in the definition that...
Well, because standard variable rate uses the defined term interest.
And interest is what you charge using the mechanics in condition 6 at the interest rate. The interest rate is what the offer says. The offer says you look at the standard variable rate. So you're back at the standard variable rate definition.
The standard variable rate is the base to calculate the interest, yes.
Yes.
But what that's all I'm drawing from this, I'm trying to attack the targets that have been set, is that these provisions are talking about the interest set under these terms. It's as simple as that. It's not talking about a coterie of different rates to different portfolios.
Well, maybe I'm misunderstanding what significance or otherwise you're attaching to that. But look at the definition. It says the rate you decide to set as the base from which to calculate interest on our variable rate mortgage loans. I'm not quite sure where the rest of it really helps.
That's fine, my lord. I mean, I'll come back to attack their points.
okay.
Maybe it's not part of my case. My case is fairly straightforward, but I'm trying to deal with the textual arguments that are being made against.
But,
Your point is straightforward. You can't refer to interest rates set under completely different contracts.
Exactly. That's all the point I'm making, and that's apparent from the language. That may be obvious anyway without the need for the defined terms, but I think the defined terms are relied upon by my own friend.
and where I'm getting confused is when Mr. Soul was referring to this yesterday and seeking to explain what he understood you were saying, I'm not sure that was quite what he thought that you were saying. But it probably just doesn't matter. I mean, you're not making any particular point about condition 6, for example, which I think Mr. Soul was suggesting you were.
Well, I think the only point I was going to make in light of the discussion you had was that I think it was said by Mr. Soul that no, interest wasn't charged under condition 6. I think there was a point made about that yesterday for the first time.
Well, I thought he was saying that, this is remembering probably, I thought his idea was that you were saying that somehow this was all tied to what you did under condition 6, and condition 6 relates exclusively to this portfolio or something. But that's not part of the argument.
Well, my lord, it is, because what we're saying exactly as my Lord Justice Arnold's saying is these conditions govern the Whistletree portfolio and
Yes.
provide how interest is to be charged and calculated. These terms don't therefore incorporate the ability to import different interest provisions applied on different portfolios governed by different contracts. And that's why I'm relying on the defined term saying that interest is the interest charged under condition 6. It's not simply the interest that is we charge as a bank from time to time.
Yeah, okay.
Mr. Soul, I think, asserted that you attached importance to the use of a capital letter.
Yes.
Do you? And if so, why?
Well, I attach importance to the defined term, which appears in the definition of standard variable rate and throughout. A point was made by my Lord Justice Newey that the capitalised term doesn't appear in part of condition 19. And the answer to that, and I was going to come on to this, but if we look at it, the answer to that is that if we read condition 19.1 on page 160, we may transfer or charge or otherwise dispose of the offer as defined or any of our rights under the offer, including the right to set the interest rate as defined to any person, where we transfer to any person the right to set the defined interest rate, which is the one under these terms, and we have set the defined interest rate by reference to the defined SVR. So far, this is all under these conditions. That person may set now lowercase interest under the offer by reference to the person's own or one of its own standard variable rates, lowercase. And that is because until the person has set the interest rate under its own standard variable rate, it doesn't become a capitalised interest or SVR capitalised. That's what the difference is.
Once it does.
And once it does, it then becomes, as they say, the SVR, and that's clear from the definition of SVR, which you see going back to page 155, if we transfer or dispose of the offer, the person to whom we make the transfer may change the rate to its own base rate, which it applies to its variable rate mortgage loan, so all lowercase. That rate will then be the capitalised standard variable rate.
Does anything else turn any other capital letters used to start any other words in these documents?
I don't think so. I'm just simply using the defined terms, my lord. It's not the capitalisation, it's the defined terms that I'm relying on. And the reason is because my learned friend tries to rely on certain terms, like the word standard, as not a defined term, and that's why I'm emphasising it. Or he tries to say as part of his case that TSB was obliged to, if it was to vary the interest rate, to apply its pre-existing rate. And that's why I'm showing you how these conditions operate under the defined terms.
So can I just understand where you do end up? You say standard variable rate is the rate that, let's forget about TSB for a moment, because we'll go back to when it was Northern Rock. Standard variable rate means the rate that Northern Rock decides to set as the base from which to calculate interest just on these loans? On what loans?
On the loans governed by the general conditions and in the offer. That's what it says, and that's so it is these loans, those ones that are governed by these terms.
So just to be clear, when you go back to say page 170, the guarantee, set as a rate guaranteed to be below our prevailing standard variable rate. There's absolutely no constraint on what you can set as the standard variable rate.
Well, the standard variable rate is as defined.
Which can be, I mean, it only has to be less than 100% if you choose to set the figure at 100%.
Well, not really, because the standard variable rate is a numerical rate.
I know, but how do you determine what it is? It's a figure that you set.
Don't we get the answer to that from the definition?
Yes.
Current standard variable rate, which applies to your loan, is set out in the offer. So the starting point
Exactly.
is in the offer. And then it says we may change this rate from time to time under condition 7 or the offer. So in order for you to charge it, you have to start with the rate in the offer. And thereafter, you can change it under condition 7, which is to say you can reduce it freely.
Exactly.
And only increase it if one of the conditions specified in 7.2 is satisfied.
Exactly. And that's the answer to my learned friend's consumer protection point, that that's the protection, you can't just increase it. And the reason you need clause 19 is because 19 gives a transferee lender the ability, in this case TSB, the ability to start from its own rate, but it's got to be a pre-existing rate. It can't be just one plucked out the air.
Okay. I don't know that any of this matters, but I would like just to understand. So if we take, say, the offer at tab 10, that says that the initial rate is 5.99%.
Yes.
And then it says on expiry of the special rate period, the rate will be set at a rate guaranteed to be below the current standard variable rate set by us.
Yes.
Now,
It also sets out the current standard variable rate in box 4. Box 4 gives the current standard variable rate, which is 6.59%.
Yeah, let me just see if that does solve my problem.
165. And then there are only two ways that can be changed, my lord.
No, I follow
Condition
the
19.
7 and whatever point. So is the hypothesis that rate is not something that can be judged externally at all. It's something that exists as the SVR simply because it's specified in this agreement.
I think that's right, my lord, but obviously there will be market conditions, so you couldn't just set it at 20%, because you have to get the borrowers to borrow with you, obviously.
But you can't compare with any other Northern Rock document to see what your SVR is. It's simply the figure specified in this offer.
Yes, because the comparison of Northern Rock's rates would come before you presumably sign up to the offer. As we know, mortgages all have different rates with different benefits, and then you take out the mortgage, it has its rate on its terms, and
so
then it's varied in accordance
Yeah,
with it.
but rephrasing my lord's question, the issue is how one determines, let's say, 4 or 5 years down the line, what the actual standard variable rate is. To which I think your answer, but correct me if I'm wrong, is you start with what's in the offer. That tells you what that rate was at that date, and then you trace through to see how it's been changed subsequently in accordance with condition 7. And what condition 7 doesn't allow you to do, you say, is to impose, for example, an arbitrary increase unrelated to any of the justifications set out in 7.2.
And that I follow. But supposing you had made 2 offers on the same day, you could perfectly well, could you, have given the SVR as 6.59% in one, and the SVR as 7.59% in the other, and then you could have changed each of them as you chose subsequently. There would be no external measure of SVR.
Well, my lord, I don't think that's right if it's applying to the same portfolio.
I'm not sure why not.
Well, can I say, my lord, 2 things. One, with respect, this isn't any part of.
No, I see that.
And so it is quite difficult without the
Yes.
factual material, and it's not any part of my learned friend's case either. But doing the best I can, the second point is that portfolios, and I think you can see this from the evidence of Miss Lamb, who talks about the fact that different portfolios have different SVRs. And indeed, that's been part of my learned friend's case, that TSB applied different SVRs across different portfolios. And in fact, one of the portfolios of TSB was in fact higher than this. And indeed, I think we saw yesterday from the evidence Landmark's portfolio afterwards hasn't been significantly better than TSB. So what you see is that SVRs are applied across a portfolio basis. So if your lordship's question is it likely that Mrs. A taking out a Whistletree mortgage gets one rate and Mr. X gets another, the answer I would give you is I don't think so under the Whistletree portfolio. If Mr. X was taking out a buy-to-let mortgage, there might be a different rate. But that they are tracked, as you can imagine, my lord, I don't think banks would have the ability to make such individual offers to all of its customers. It's done on, and that's one of the reasons
The
you have.
contractual framework would allow for it. It's just commercially unrealistic.
Indeed.
Because banks are never going to micromanage
Indeed.
to that extent.
That's precisely right. And that's why, though, the reason you asked me, why am I focusing on interest, is because the capitalised interest is that the first sentence of the definition of SVR cannot refer to TSB's pre-existing SVRs because they're not covered with interest as in the defined term. And that's what the judge found in paragraph 40 of his judgment in the core bundle at page 64. In other words, it is interest charged under a particular condition within the general conditions, and that is the point, that it doesn't import any different rate of interest.
I mean, I do suspect none of this matters, but just coming back so I understand again, if we come back to the definition, the rate that you decide to set as the base from which to calculate interest, well, interest, I would say, is the interest charged under the offer.
That's right, and that's fine. But
On
it
our
doesn't just
variable
sorry,
rate mortgage loans. So what does on our variable rate mortgage loans refer to? It's not just this loan.
I think that's right, my lord. I don't think it is, but it's on our variable rate mortgage loans, which isn't a defined term, disregarding the restrictions on what we can charge under condition 7 of the offer. So the standard variable rate is the base from which we calculate interest as defined on our variable rate mortgage loans, which can only be those subject to these conditions, because otherwise the capitalised interest wouldn't apply to other portfolios. That's the point, because they don't apply. The other portfolios wouldn't be governed by condition 6.
Condition 6 is only about mechanics, but let's leave this. But
Well,
yeah.
just to pick that up, my lord, it's not just about mechanics, because condition 6, if one looks at it at 157, says at the end of 6.1, you agree to pay us interest on all amounts debited to the account. So it's not just about mechanics. There are obligations. So it does talk about.
But it's talking about how interest is calculated and charged. It's not talking about rates.
Well, that may be right, my lord, but it also does include the obligation you agree to pay as interest on all amounts debited to the account. I appreciate that these conditions, and that's why my Lord Justice Arnold pointed it out, I think they are different because they refer to both documents, the general conditions and offer, and they do seem to both apply various obligations. And I accept that if there's a conflict, the offer letter would prevail, but it's not being suggested they do.
No.
But I don't think it's right to say that 6.1 is simply about mechanics, because it says it's how it's calculated and charged, and there is an agreed obligation in there. And it's also, if, for example, if you look at little d at the end, you will pay interest on the special capital repayment. So there are obligations as well as the calculation methodology within there. And you can see things like interest is due on the date it's debited to the account 6.4. And 6.6. So I appreciate it is how it's calculated, and that's what it said and charged, but it's not correct to simply say it's mechanics. And the reason it's relevant, trying to answer your question, in the definition of standard variable rate on the second line is because, and this was my argument below as the judge reflected in paragraph 40, it is importing the concept of interest, not TSB's pre-existing interest rates, but what is charged on these mortgages. And that's the simplest way I can put it. The use of the defined term makes it plain that we are talking about the interest rate applied to these mortgages and not of different books owned by any other lender. And my lord, just to make that good, if it was referring to interest on different books by any other lender, it's not clear why you would need the second half of the definition, just like 19.1.
Sorry, say that again.
Well, if interest and variable rate mortgage loans had a wider meaning than the defined interest, it's not clear why you would need the second half of it, because interest would, on my learned friend's case, necessarily import the transferee's own rates.
Second half of which one?
Definition of standard variable rate.
And by the second half you mean?
I mean, if we transfer or dispose
I
of the
see.
offer. If your lordship is content that I've answered it, or at least tried to, may I turn now to how the SVR is varied under the contract, which I appreciate you're familiar with, so I'll take it quickly.
Yep. Yes.
There are obviously two independent mechanisms. Just as my Lord Justice Arnold said, there is condition 7, which is the general mechanism at page 157. And you see that is headed changing the interest rate, and exactly as we discussed, one can freely reduce the interest rate, but the increase can only occur in accordance with the conditions. That's the general mechanism. There is then a special and additional mechanism in clause 19 on page 160, which applies only upon transfer to a new lender. Now, just looking back at condition 7, just to be clear on the language, and that's 157, we may is the language used in both 7.1 and 7.2, so it's permissive, it's not obligatory. 7.2 has a restriction, but just both of them also have the words at any time. So we may at any time reduce, we may at any time increase if. Now, it's not a condition in this text that you can only do so if you're a new lender, if you're applying your own rate. So it doesn't appear in clause 7, my learned friend's case. And then if we look at the special mechanism, it doesn't appear there either. So 19.1 at page 160 says we may transfer, etc. When we transfer to any person the right to set interest rate, which, just to pick up on the point made, would be included in the offer, and we have set the interest rate by reference to the SVR, that person may set interest charged under the offer by reference to that person's own or one of its own rates. So the first sentence, the current lender, we, is permitted to transfer the offer, including the right to set the interest rate. The second sentence, which I know your lordships have, is that it provides that a transferee lender may set the interest rate by reference to its own rate. So again, it's permissive. There's no suggestion it's mandatory under any conditions. And you then also see the point that it's at that person's own discretion as to which of its rates it chooses, and there are no restrictions on that. And it's difficult to see. My learned friend advanced a case that the implied term somehow would come into play, but it's not a case that's been articulated before, and it's not clear how it would limit the obligations in the way that my learned friend suggested, given the express nature of the terms, and the two can't be inconsistent. And there's no suggestion of unfairness, because it's got to be one of the person's own standard variable rates, i.e. it's got to be in existence. So it doesn't give scope for somebody to say, let me just charge 20% because I can. So it's not clear how an implied duty of fairness would restrict this, and it's not clear how an implied term would rewrite the terms of the express term, nor has it been articulated. So on its face, the two mechanisms make it plain that at any time, either the original lender or the other lender can vary the interest rate that has been set in accordance with condition 7. And the only gloss for a new lender is that it can impose its own rates, even if higher, at the time of transfer, without having to comply with condition 7.
And you're not relying on the special mechanism in 19.1?
We're not, because we
No.
didn't do that.
No.
And so we also say that in a sense, my lord, and you're right to pick it up, that that sentence is irrelevant to what happened on the facts in our case. So in fact, there is literally no textual hook for my learned friend's case that upon transfer, you had to do something different. in a sense, his case stands and falls, therefore, with the case that he's already conceded doesn't work.
And since you're not relying on it, it doesn't really matter. But I think you were accepting that if you wanted to use that special mechanism, you would have to use a pre-existing rate.
Yes, we do.
And the
That's what it says.
pre-existing standard rate.
Pre-existing standard variable rate. And as you saw from the agreed statement of facts, we had a number in play.
Yes.
We could have picked one of the higher ones and just imposed it, but and that's the purpose of saying you don't have to comply with clause 7, but that's not what we did.
No. So on your case, which doesn't matter since you're not relying on this mechanism, the transferee would have to choose a rate that applied with some generality so that it was a standard rate.
Exactly.
And it would have to be a pre-existing rate.
That's right.
But you say, forget about all that because we're not relying on it anyway.
That's right. So we don't have to get into an inquiry as to what the appropriate rate could have been, might have been, which forms part of my learned friend's case. We didn't do it. And as I say, the important point that comes out of this discussion, my lord, is that it is important to emphasise that once one takes away that mechanism, it's unclear how my learned friend gets to his argument, other than possibly through his version of the word interest.
It's no part of your case, or not relevant to your case, therefore, to consider what happens if the transferee doesn't have prevailing or pre-existing or whatever rates, standard variable rates.
It's absolutely no part of my case, but it is relevant to debunk my learned friend's case because it shows the problem with it.
So how would you do that?
Well, my learned friend's case assumes that there is a pre-existing rate and or some obligation to pick a particular rate.
I think he conceded that word should be read into 91.
Exactly. But that's part of his case. That's part of his case. You either have to, first of all, you have to have the pre-existing rate, and secondly, you have to read in the words into that sentence. And when one stands back and says, but what if there is no pre-existing rate, his argument that the new lender has to apply it falls over.
So on your reading, there's no requirement to limit the transferees to people with pre-existing prevailing rates. No. But if it is transferred to someone without such rates, they are constrained by 19.1 as to what they can and cannot do.
Exactly. And that, as we understand, is precisely what's happened with all the other lenders that I showed you in Mr. Parker's statement, Topaz and Landmark. And that is why the claimants are not, as we understand it, intimating a claim against them for breach of the express terms, because they had no pre-existing rate and have simply applied the Northern Rock rate. But interestingly, they are not suing those lenders, as far as we're aware, for breach of the express terms in the way that it's being articulated here, because they couldn't do so. And so they're left with an implied term case. So you can see immediately the difficulties with their argument, even in their approach to different lenders that are being sued.
So to rephrase what you've just said slightly differently, your submission is that if a lender who has no pre-existing rate is entitled to take the inherited Northern Rock rate and then vary it pursuant to condition 7, the same, you say, must be true of a lender who does have a pre-existing rate, because the second bit of 19.1 is purely permissive.
Exactly, precisely right. And there is nothing, and crucially, my lord, there is nothing in the text that would indicate to the contrary. And my learned friend's argument is, of course, put on a textual basis, which he says is supported by the context. And there is nothing in the text to support it. So my lord, can I pick up one question I said I would come back to, and it may be that it's not relevant in light of the discussion we've had, but I wouldn't want to leave it unanswered. Your lord asked yesterday at page 82 of the transcript whether a transferee lender could follow the rate set by the transferor after transfer. So assuming for the sake of the argument that Northern Rock had continued to exist and set and vary a standard variable rate for the mortgage book, but it would be a different book to this one. And I think what your lordship was envisaging by the question is that the SVR that applied to the Whistletree mortgages would track the SVR as varied by Northern Rock to the different book of mortgages.
Yes, I mean, supposing that Northern Rock had just continued as was,
Yeah.
it certainly wouldn't seem unfair on a borrower if a transferee had the choice of either following Northern Rock rates as they happen to be from time to time, because that was what they signed up to in the first place, or alternatively, they have the transferee's own standard rates, whatever they happen to be.
So, my lord, I think there are three answers to that. And obviously, the first is that we don't know that Northern Rock continued to exist and set rates. But so the hypothesis is not something that we think has happened in reality. But irrespective of that, the second answer is it is not permissible under the general conditions for two reasons, and they're sort of two sides of the same coin. The first is that the transfer by the lender, and this goes back to my learned Lord Justice Arnold's point, the transfer of all the rights of the lender, including the right to set and vary the interest rate, are transferred under condition 19.1, and the terms on which the borrowers signed up was that that could be done and done without their consent. And if the right to set interest has been transferred to the new lender, TSB, then Northern Rock, the old lender, can't continue to effectively operate the SVR that applies to the mortgages now owned, if I can put it that way, by TSB. TSB can't simply, and I think this was your lordship's question, track what Northern Rock does either, because TSB's rights to vary the SVR are constrained by condition 7.
And by the definition of SVR?
And by the definition of
The
SVR.
second half of the definition
Indeed.
provides what the SVR is after transfer.
Exactly right. So that's exactly right, my lord. And so the only thing that TSB could do is what it in fact did, which is to take the numerical rate, the SVR set by Northern Rock and inherited by TSB, not change it, but then vary it in accordance with condition 7. And you can see that that's quite important, because otherwise condition 7 wouldn't be, and condition 7 is for the protection of the borrowers, so it couldn't be right that another lender could operate it. Can I then turn, my lord, to the claimant's case? I've covered quite a...
Just before you do, even though this is also relevant, you mentioned the landmark position, and you've mentioned that there are proceedings against other incoming lenders.
Yes.
Are there proceedings against landmark?
Yes, but well, I say this, my lord, we've got this from the statement of Mr. Parker, and I don't know whether proceedings have been issued or claims intimated, but I'm just taking the solicitor's, the claimant solicitor's statement. If I can just show you what's said again. It's tab 16 of the supplemental bundle, and it comes right at the end. So you see with the paragraphs we looked at yesterday, so you start at
78, he says claims against landlord.
Exactly, and if you start at 76 on page 222, the heading is interaction with other claims against other potential defendants. And he says in that paragraph, there are other groups of former Northern Rock customers who have similar claims against lenders.
Yep.
And he sets out the background of them, and then exactly as my Lord Justice Arnold has said, that he's instructed to bring claims against Landmark, NRAM and Topaz.
And we don't know how any claim against landmark would be, landmark or NRAM Limited or whatever would be framed.
Well, we do, because he goes on to say in 79 that the core claim against those defendants is similar to the implied term claim described at paragraph 51 above, which is the fairness claim.
Yeah, and he makes the point in 81 that the non-TSB defendants are different because they're inactive lenders, i.e. they do not undertake new mortgage lending at competitive rates.
Exactly. So that's why we are saying that it appears that none of them had therefore a pre-existing rate. So the only claim is no claim for breach of the express terms to vary. Their claim is simply the implied term case.
Well, yes, that may be true so far as e.g. Topaz is concerned, but there may be a question mark over that to the extent that Landmark is the same corporate entity under a different name.
Well, I'm not sure that we know the details quite of Landmark, because there was also, as you can see, an NRAM entity as well. So I'm afraid we don't know the ins and outs of that. All I can say to you is that what is said in 81 says it's true of Landmark, NRM and Topaz equally. So this is their solicitors.
To be sure, but it might have been overlooked as it was the same corporate entity, if indeed it is the case.
Well,
that's
can I-
not 100% clear.
That's right, my lord. I can't comment on that. I've not seen
No,
what the claims are, but the implied term is the paragon term, which is the capricious exercise of discretion to vary the rates rather than a breach of express terms. And that's all. So there is a claim about variation under that way, but not.
So we don't actually have paragraph 51 in the bundle. I'm not complaining since it's
like
not.
a copy of it.
Well, I'm not sure since it's not really relevant. So 51 would refer to.
That would be the implied term as originally formulated, presumably.
I don't think it does. That was also the interest. It's unclear to me, and that's why I have to be careful. But I don't think in these claims the implied term was formulated in all of them as it was originally in this case, and it was more along the lines of the paragon claim. That's my understanding, but I may be wrong. And so for present purposes, I don't think it goes wider. But the point that's made by the claimant solicitors here is that the core claim is the implied term claim. It's not the express term claim that you see in these proceedings.
Yeah.
So my Lord Justice Baker's point is absolutely, and Lord Justice Arnold's point is absolutely right, that it's not being said, according to this statement, that those lenders were constrained in the way that it said we are, and that our terms and conditions should be interpreted.
Yeah.
And of course, those would be the same, similar terms and conditions for the other lenders. So may I just turn then to the points made by the claimants, which are first linguistic points, textual points, and secondly contextual points. I've actually covered a lot of this, so I will try not to repeat it. But they mount 4 arguments said to be derived from the language of the contract. The first argument is in their skeleton argument at paragraph 14(1)(a), and also 24(2), which relies on the words our variable rate mortgage loans in the definition of standard variable rate. And the skeleton argument is at tab 14 of the core bundle. Page 215 was the first reference. So its variable mortgage loans is said to mean its pre-existing portfolio of loans. I'm just going to outline what their arguments are and then I'll come back to them. The second argument seeks to rely on the use of the word standard in the term standard variable rate, and that's at 24, paragraph 4 of the skeleton. The third argument is that the reasons under condition 7.2 permitting a lender to increase the SVR must relate to the current lender. And the fourth argument relies on language in some but not all of the offer letters that refers to the prevailing standard rate set by us from time to time for existing Northern Rock borrowers. I should say that the third and fourth arguments weren't, I think, particularly developed at all orally, but they are in the skeleton. So turning to the first argument, our variable rate, the phrase our variable rate mortgages can't mean what it's said to mean by the claimants, a pre-existing portfolio at the loan at the time of transfer. And we address that argument at paragraph 33 of our skeleton. And it's wrong for 5 reasons. First, the term is inconsistent with the reference to the defined term interest in the definition of standard variable rate, i.e. interest as charged under the general conditions. And this is the argument we've canvassed at length. TSB does not and did not charge interest as defined under its pre-existing portfolios. So the standard variable rate can't refer to a different rate of interest applied to a different portfolio. And the judge correctly noted at paragraph 124 of his judgment that the claimants have no real argument against this point. The second reason that it's wrong is that the argument is inconsistent with their own concession that TSB was not obliged to adopt a pre-existing SVR. The third point is that my learned friend said yesterday at page 91, line 17 of the transcript, that the language in the definition of the SVR was OTOs on our case. And I covered that. In fact, it's the other way round. The fourth point is that the claimant's argument only engages with the scenario where the new lender has a pre-existing SVR. And again, we've addressed that. And the fifth point, sorry, I'm just I'm being passed a
So I didn't quite catch point 4 as being, could you say that again?
Point 4, my lord, was that the claimant's argument only engages with the scenario where the new lender has a pre-existing SVR, which we've covered. And just to test that, on my learned friend's case, those lenders shouldn't be able to vary the interest rate at all. But that isn't what is being said, as we've discussed. And the fifth point is that the claimant's construction that its variable rate mortgage loans must mean its pre-existing portfolio of loans at the time of transfer, again, only works if the transferee lender has a pre-existing portfolio of loans, and indeed, possibly only if it has a single one. Those are the textual answers to that first point. The claimant's second point is that the word standard in the term standard variable rate connotes a rate that would apply generally across the board and not a rate specifically devised for transferred borrowers. It's not clear what's meant by generally across the board, nor is it clear what the classes of borrower the classes of borrower with the lender are. This is all in paragraph 24.4 of my learned friend's skeleton. It's not clear how that would be judged by whom, and there's nothing in the contract that assists. And TSB did not, in any case, devise a rate specifically for transferred borrowers, which is seems to be the premise of the argument in paragraph 24.4. As we know, TSB retained the rate that Northern Rock had set and varied it in accordance with condition 7. So aside from the obvious textual answer, which we canvassed this morning earlier about the defined term anyway, the argument doesn't even work if you unpick it, taking away that textual point. And in any case, the word standard is entirely apt to describe a base rate that applies to all mortgages under the general conditions, i.e. those on which interest as defined are charged. My learned friend's third argument is at paragraph 24, subparagraph 7 of his skeleton argument, and it focuses on the reasons for which a lender is permitted to increase the SVR under condition 7.2. As I said, I'm not sure that this was developed orally, but briefly, the position is that the permissible reasons are set out in condition 7 in the supplemental bundle, tab 6 at page 138. So I think that's the earlier version that I gave it to you, and the version we've been looking at, tab 9 at paragraph, page 157, paragraph 7.2. And if TSB wanted to raise the SVR under 7.2 little b, which is for good commercial reasons we need to fund an increase in the interest rates we pay to our own funders, this would have to be justified by a reference to an increase in TSB's cost of borrowing. The reference in 7.2b to the interest rates we pay to our funders means following transfer TSB's funders. The definition of our in condition 1.1 includes a transferee lender. My learned friend suggests that this wording means TSB must adopt a pre-existing SVR, i.e. Northern Rock's funding, in order to vary the rate under condition 7.2. But this is simply a non sequitur. There's no basis on the language for this, and there's no commercial sense in it either. And then the fourth point on my learned friend's textual arguments is in his skeleton at 24, subparagraph 5, which is the argument based on the words, the prevailing standard variable rate set by us from time to time for existing Northern Rock borrowers. An example of that wording was in the offer letters, which you saw, and the judge dealt with this at paragraphs 103 to 113 of his judgment, and we address it in our skeleton at paragraph 35.3. When applied to a new lender, this phrase means that the new lender must set the interest rate for the specific mortgages benefiting from this term below the standard variable rate set from time to time for the other mortgages that are subject to these general conditions. And it would be a nonsense if the phrase was interpreted as referring to pre-existing TSB borrowers for all the reasons I've already addressed you on. So, my lord, those are all of the claimant's textual arguments and our responses to them. And importantly, standing back, as I've said, and I don't want to repeat it, but as I've said, neither condition 7 nor condition 19, in fact, support his argument, and he's left trying to discern words within other parts of the contracts to try and build a case, but it doesn't work even on the analysis of those other words. But it is striking that the contract doesn't come close to saying what it ought to say on his case, particularly when condition 7.2 has restrictions set out in it, but not the crucial one he seeks to introduce. In light of that, my lord, one doesn't, in my respectful submission, even get into the contextual arguments on this appeal, because my learned friend's case is hopeless on the clear language of the contracts. But even if it was necessary to go outside the terms of the contract, the relevant context reinforces the textual conclusions for 4 reasons. The first, as I've submitted in the textual context, is that the claimant's interpretation of the contract does not work where there is a transfer to a lender with either no pre-existing SVR or more than one pre-existing SVR. Now, just to deal with one point, my learned friend suggested that one must look to the most comparable class of borrowers, for example, in his skeleton argument at paragraph 24, subparagraph 4, and I think yesterday in a debate with my Lord Justice Baker. The claimant suggests that the relevant comparable is the dates when the mortgages were originated. That's in footnote 43 of their skeleton argument on page 10. And it said that the most comparable of TSB's pre-existing borrowers were those whose mortgages were taken out before 2010. That doesn't make any sense. The fact that certain of TSB's other mortgage borrowers also took out their mortgages before 2010 tells you nothing about whether those borrowers were similar to the Whistletree borrowers or whether their mortgages were similar to the Whistletree mortgages. So it's not clear why that would be the comparable. And the truth is, it's not easy to determine which of any lender's existing mortgage portfolios would be comparable to the Whistletree borrowers, or even how that comparison would be made. And that's especially true for the customer. So, of course, one has to look at their position. How is he or she meant to deduce what rate their interest should now be calculated at when it doesn't know it, when they don't know anything about the circumstances of TSB's other borrowers? And it's simply a recipe for confusion.
Presumably there are classes of borrowers and classes of mortgages which are similar, and respectively comparisons can be made. Never possible.
I don't know with the Whistletree portfolio whether that's right, my lord, because
the Whistletree portfolio and the Together mortgages were of a very particular type.
That's right. And of course, this is talking about these borrowers. And Miss Lamb describes in her statement that this was a particularly risky class of borrowers. So it's not obvious that, put it this way, my lord, Northern Rock collapsed, and it was because of the government intervention that various banks took on the portfolios. It's not obvious that those banks would ever have lent to these borrowers had it been left to them. And that is why it's not clear cut. That's the highest I can put it, because I'm putting across the board with the other lenders as well, who had no pre-existing rates, of course, but TSB. It's not obvious that TSB would have had any other comparable class, and the ones that had no pre-existing borrowers clearly didn't. So that is why this whole suggestion that you would look for a comparable is quite difficult. But what can be said is that the claimant's case that you just look at when it was originated doesn't provide a comparable. The second point, my lord, is that there is no merit in my learned friend's herd immunity argument. That's at paragraph 26 of his skeleton. Again, this is about the fact that if TSB was obliged to charge the same rates as its pre-existing customers, then that would somehow give protection to the Whistletree borrowers. And there are 3 answers to this, and forgive me, they are repetitive, but just to give you the answers. The first is, again, this argument assumes the transferee lender has a pre-existing portfolio of variable rate mortgages. If it doesn't, there is no herd in which to seek protection. The second point is that the argument assumes that the relevant pre-existing portfolio enjoys lower standard variable rates. Because on the claimant's construction, if the portfolio had higher pre-existing SVRs, the lender would be obliged to apply that higher rate across all mortgages. So the herd would not be getting protection, but actually collective detriment. And the claimants notably have no answer to that. The reason they make the argument, of course, is it works with the benefit of hindsight because they are trying to find a rate that's most favourable. But it would be surprising if a new lender was obliged by a consumer contract to impose a higher rate, as the judge recognised in paragraph 133 of his judgment. And then the third point is, as the judge noted at paragraph 93 of his judgment, the alleged need for protection by herd immunity is undermined by the agreed position that the lender's right to set interest rates was subject to an implied term. And the implied term is to the effect that the power to vary must be exercised in good faith, not arbitrarily, capriciously, or irrationally. And then the final point is simply on this is the regulation 7.2 of the UTCCR relied on my learned friend, and I can deal with this very shortly. Although we are dealing with consumer contracts, your lordship is not assisted by this regulation because it provides that where there is doubt about the meaning of a written term, the interpretation which is most favourable to the consumer shall prevail. The first point is that the interpretation which is most favourable to the consumer must be assessed as at the time of the contract. So it's not open to these claimants to rely on an interpretation with the benefit of hindsight. If it was assessed at the time of the contract, the interpretation they posit wouldn't necessarily be the most favourable to the consumer, given it could impose a higher rate for the reasons I've just given. And the second point is, if it's not assessed at the time of the contract, the meaning of the term could vary, which would give rise to uncertainty. And obviously, those two arguments simply grapple with the claimant's position, assuming there were uncertainty, whereas of course we say there is not, but it has no application. And then coming back to my learned friend's case, my third point is that there is no merit in the claimant's general complaint that it's somehow unfair or implausible that they were not entitled to benefit from the lower SVRs that TSB applied to some of its other mortgage portfolios. The claimants are not worse off as a result of their acquisition of their mortgages by TSB. Their claim in substance is that they did not enjoy a windfall as a result of that acquisition because TSB had some lower rates, which they now wish to take advantage of. The claimants are in fact better off than other former Northern Rock customers whose mortgages were acquired by dormant lenders or other unregulated investment vehicles because the claimants were able to access product transfers made available by TSB. And I think about, well, at least half of the Whistletree customers of TSB took advantage of those. That is by the by, but it's important context to my learned friend's argument. The key point is that there is no reason why these claimants should be offered the same terms as other customers of TSB who are different in terms of their needs, their profiles, and subject to different lending criteria. And the protection they have is in 7.2 and also 19.1 of these conditions, namely that the variations could only happen in accordance with certain parameters. In any case, there is their claim under MCOB, which I'll come on to in the context of issue 3, which provides a comprehensive and detailed regime and they have those claims, they pleaded those claims. So if there were unfairness, that would be the area that they would seek to rely on, no doubt. And the fourth and final point is that the premise of the claimant's case that TSB should apply the same SVR across different mortgage portfolios could lead to absurd anomalies in practice because of the different terms and conditions that apply to those different mortgages. Because it could mean that these claimants were worse off if that were really true. And the claimants don't provide any answers to obvious questions such as, if TSB wished to decrease the SVR under condition 7.1, does that mean it has to offer the same decrease to all of its mortgage customers so they would get a windfall? So, my lord, the contextual points add nothing except to expose the weaknesses of the argument. And as I say, that argument's already been grossly compromised by the concession that was made. So, my lord, we suggest that the interpretation of these conditions is clear on the face of their terms, and they certainly don't bear the meaning for which my learned friend now contends.
Do you have any submissions on the points he made about Mr. Justice and Lord Newberger's opinions?
I don't, my lord. Your lordship has Supreme Court authority about the nature of interpretation of contracts, and I have to say, with respect, this court doesn't need to be told how to interpret a banking contract. And all that Lord Newberger has said consistently, whether at first instance in the Court of Appeal or in the Supreme Court, is that one looks at the words and then one is entitled to cross-check their commercial sense. But the words are to be given their ordinary meaning, absent some absurd anomaly or consequence that could not have been attended. Here, my learned friend's position requires the court to engage in either some form of gymnastics, mentally or linguistically, and I think it's fair to say, actually rewriting the accepted condition 19.1, but in fact it requires a rewrite of condition 7.2, which doesn't exist and there's no basis for.
Thank you.
I don't know if the court, my lord, has any other questions before I move on to issue 3.
I don't detect any. So, issue 3.
So, my lord, the position on issue 3 is that the issue is focused on a discrete point of statutory construction, and it's arisen through a series of concessions in order to get to the point. In particular, for example, it has been agreed for these purposes only that the mortgage is a related agreement. That is not, in fact, accepted and will be challenged if this goes further, because, in fact, we suggest the position is absolutely obvious that it's not a related agreement. But for the purposes of examining the scope of section 140A5, and that's the only point, it has been agreed in order for your lordship to make the assessment of the ambit of that section.
And just to understand that, you say you wouldn't accept that this mortgage was a related agreement if it mattered. Would you accept that mortgages can be related agreements?
No. We don't accept that mortgages are related agreements. That's ever. That's a different argument. And the reason for that is that we say that mortgages have been removed from the Consumer Credit Act intentionally by Parliament and are separately regulated by a different regime by the FCA and under MCOB. And the reason for that is very clear, because if you interfere with mortgages, there are all sorts of consequences that can be quite serious, which is why it's been taken out of this regime. Plus, if they were related transactions, that would have a number of knock-on consequences because the concept is used throughout the CCA and the CONC. And so to give you one example, the APR for a loan would need to take account of the interest paid on the mortgage. So it would make the loan look disproportionately expensive. So there are all these consequences, but none of this concerns you because whether or not the Whistletree mortgages are linked transactions and therefore could be related agreements.
It does concern us because you are asked to decide an issue of statutory construction which may never arise. It could be entirely academic because if you're right that a mortgage is never a related agreement, we never get to this question.
That's right, my lord, but we have agreed preliminary issues in order to
Well,
short circuit that debate.
But since when do parties have the power to require the court to decide questions which may be academic?
Well, my lord, what wouldn't be academic is the trial that would need to occur if that debate was had, because it's not a question that lends itself to a preliminary issue. It would require disclosure because the debate we would have would be on the Whistletree mortgages. And that would require...
So I don't understand that because your answer to my Lord Justice Newey's question was based on mortgages never being related agreements. So why do you need the terms of the Whistletree mortgages in order to decide that issue?
Well, my lord, can I clarify that? Because I may have put that too widely. I think my point is better expressed that in practice, mortgages can never be a related agreement. There may be a theoretical argument. So that may be a better way of expressing it. And that's why it wouldn't lend itself to a preliminary issue or a debate generally in a trial of this claim. We would be arguing on the facts as to whether or not these mortgages were in fact linked transactions.
Are you arguing, are you taking both points or just the latter point?
My lord, that would be to be determined. At the moment, we've pleaded just the latter point because that's what we would debate. We don't need to go further to take the more general point. I was simply giving you an example generally of why I say it's unlikely that any mortgage would be a related agreement, why we make that argument. But I don't want to... We would have to show on the facts here an investigation into how the loans were marketed, initiated, and so on. It's in, you can look at this in the general particulars of claim at paragraphs 34.1 and 34.2. And because of that, in fact, my lord, in a sense, it's the opposite way round, my lord, that we would be trying to make that issue academic, which is a more fact-specific issue on this case, in order to say that even if you assume the claimants are right and these regulated mortgage contracts are related agreements, it doesn't matter because no order can be made in connection with them because of section 148(5). And that's the debate before you.
So just to be clear, I mean, this point might worry us a bit if it could affect how we would decide the issue that is before us.
No, it doesn't.
But you say that can't be the case.
That can't be the case. I was just wanting to be very clear on the
Yes.
scope of this so that in your judgment you didn't assume that
Yes.
that was accepted. That was the only reason for mentioning it. And I'm not in any way suggesting that the court would then is deciding an issue that's academic. In if anything, the court is short-circuiting what could be a long debate because we are asking you to assume the claimants are right. But I just wanted to make the point clear at the outset because I'm not sure how clear it was yesterday, and that's not a criticism of my learned friend, it's my point, so that the parameters of this were quite clear. And just to be clear, my Lord Justice Arnold, I should reframe it because I put it in the example to my Lord a bit widely. It is, in practice, I say, unlikely that any mortgage could be a related agreement, and we say these mortgages weren't, but that we accept would be a factual inquiry on these mortgages. So may I then turn to what the issue is in section 140A5? It is that my learned friend's case is that notwithstanding, just your lordship wanted in front of you, it's in the authorities bundle at tab 17, page 339. My learned friend's case is that notwithstanding the clear terms of that section, which expressly prohibits relief being granted in connection with mortgages, the court is entitled to grant repayment of the sums due under the mortgage because of the unsecured loan. And the reason I put it that way is that is the only relief that is pleaded by the claimants against my clients. If you look at the amended generic particulars of claim at paragraph 28, in the core bundle at tab 9 at page 28,
Sorry, which page did you say?
it's
You said
one,
page, you
two-
mean paragraph.
I said paragraph 28, page 129.
Yeah.
And then if you look at the unfair relationship section at 30A,
Wrong, because I don't find any claim for relief in paragraph 20.
I'm just showing you all the relevant provisions, my lord, before I get to the release. So I've shown you everything. So there's 28 first. Then there is 30A. And then we come on to the together mortgages, my lord, in the next section, and the plea in paragraph 34 that they were related agreements. And then if we go on then, please, to the relief section, which starts at paragraph 38. You see at 39, by reason of the breach of statutory duty in paragraph 28, the claimants have suffered loss and damage, namely the difference between what they would have paid had the defendant applied interest rates based on TSB SVR and the rates actually applied. And then you see at 43.1 and 43.2. And this is where we see under the 140B CCA, as would redress, they seek an order for the defendants to repay payments made under the together loan agreement. And the reason, I apologise for taking you through it all, is because I anticipated that you'd want to see what had been pleaded before, and also what the claim was under MCOB, which I'll come on to, and you see that they mirror. But crucially for these purposes, what you can see is that the order is to repay payments made under the agreement and or the together mortgage. And that is what is being sought as the relief under section 140A subparagraph 5 and 140B. My lord, the claimant's interpretation of section 140 subparagraph 5A is unsustainable, and can I identify the 4 fundamental flaws? I will give you, in view of the time, an outline of our submissions, and then I will develop them in particular by showing you the legislative history and case law on the meaning of in connection with. But I think it's helpful before the luncheon adjournment to outline our submissions. So the first flaw, most importantly, is that my learned friend's case is directly contradicted by the ordinary and obvious meaning of the words in section 140A subparagraph 5. Section 140B gives the court certain specific powers in connection with an agreement within its scope, and an order exercising any of those powers in relation to a regulated mortgage contract would be, we say, a paradigm order in connection with that contract. And I'll show you, as I said, the authorities to the extent needed on the broad meaning given to the words in connection with. But just to give your lordship the example that's relevant, it could not be more obvious, we suggest, that an order to repay sums paid under a mortgage contract, as the relief is sought, is an order made in connection with that mortgage contract. So that's the first reason we say the case cannot succeed. The second flaw in my learned friend's case is his sole argument on the language of section 140A subparagraph 5. He says that if an order under section 140B can be framed so that it is in connection with the unsecured loan, yesterday he called that the anchor agreement, then he says section 140A subparagraph 5 is not engaged because it is not in connection with the regulated mortgage. And that's addressed in his skeleton at paragraphs 45 to 50. That argument, as we say in our skeleton at paragraph 58, is a non sequitur. Just because an order is in the general sense in connection with the unsecured loan would not mean the same order cannot also be an order in connection with the mortgage. It may be stating the obvious, but whether an order is in connection with the regulated mortgage depends only on whether there is a connection between the order on the one hand and the mortgage on the other. It doesn't depend on whether there is or isn't a connection with something else. And the same argument applies. In order to repay sums under the mortgage is obviously in connection.
To summarise that point in my own words, your submission is it's not a binary choice.
No, exactly. So that ends his point. Because even if he's right, it's in connection with the unsecured loan, it doesn't mean it's not in connection with the mortgage. And my learned friend couldn't answer, I think, the tension that my Lord Justice Newey observed in his argument, and this was at the transcript at day 1, page 162, lines 19 to 25. My learned friend needs the words in connection with to have a wide meaning as it's used in section 140B subparagraph 1, so that such an order is in the widest sense in connection with the loan agreement as the credit agreement. But my learned friend also needs the words in connection with to have a narrow meaning in section 140A subparagraph 5 to avoid them bringing in the mortgage. But as my Lord Justice Baker pointed out yesterday in the transcript at page 159, lines 12 to 13, the expression in connection with must mean the same thing in both of these subsections of the same provision. And the flaw in my learned friend's case was further exposed by my Lord Justice Arnold's question as to precisely what meaning the claimants give to the phrase in connection with, to which my learned friend had no satisfactory answer, and the reference is day 1, page 157, lines 5 to 9. By contrast, TSB's interpretation is that in connection with bears its ordinary wide meaning, connoting some form of connecting link between two things, similar to in relation to. So pausing there, for those two reasons, my learned friend's case is unsustainable on the plain meaning of the words of the statutes, and we suggest that's the end of the matter. The position, in fact, becomes even clearer if the court wishes to consider the wider context of section 140A subparagraph 5. The textual analysis and the contextual analysis point in the same direction, which takes me to the third flaw in my learned friend's case, and that is his reliance on legislative archaeology does not help him. In fact, it assists my interpretation. The high point of the claimant's argument is the proposition that TSB's construction of section 140A5 means the court has lost a power to make orders in connection with regulated mortgage contracts that happen to be related agreements of other credit agreements. And that's in my learned friend's skeleton argument at paragraphs 54 to 57. And it was supplemented before the appeal by his addendum note, which is in the core bundle at tab 16, and in submissions yesterday, to try to establish that the court did enjoy that power for a short period prior to the introduction of the unfair relationship provisions and section 140A5. And I'll come back to that in more detail after the lunch adjournment. But just to flag, we don't accept the starting premise of my learned friend's analysis in the addendum note. In fact, we say that he's not right about that. The legislative history and the explanatory materials that accompanied the legislation show a clear legislative intention to put regulated mortgages outside of the court's remedial powers under the CCA, both under the last years of the extortionate credit bargain regime and under its replacement unfair relationship regime. And in a nutshell, that was to avoid overlapping or duplicative regulation of mortgages once they became regulated under FSMA and MCOB. And that's why the judge correctly held at paragraph 206 what the intention of Parliament was, which was to exclude regulated contracts from the scope of the unfair regulation provisions. So the starting premise of my learned friend's argument based on the extortionate credit bargain regime is wrong. But in any case, the more fundamental point is that my learned friend's argument is not helpful because this court is not tasked with interpreting the regime that predated section 140A5. And again, at the risk of stating the obvious, the court is interpreting a new regime that entirely replaced the previous regime. It didn't build on it, it replaced it. And the express terms of section 140A5 limit the court's powers to make orders in connection with regulated mortgage contracts. So the historical position, which was altered intentionally by Parliament, can't override the clear terms of the statute now in force. The fourth flaw in the claimant's case follows on from the third in that it fails to take account of the regulatory regime applicable to mortgages pursuant to the FSMA Act. My learned friend's arguments that his interpretation should be adopted for reasons of fairness or consumer protection ignore the fact that there is a regulatory regime to ensure that mortgage customers are treated fairly. And as we say in our skeleton argument at paragraph 62, the claimant's remedy for any alleged unfairness in connection with their mortgages is not under the CCA, but under MCOB. And they've pleaded that claim, as I showed you, and it seems to be in identical terms. And just for your note, if you want to look back at the particulars of the claim just to see the genesis of the statutory breach, it was at paragraph 17.1 and 17.2 and 18, and that then led to the claim for breach at 28. My learned friend suggested yesterday that there may be circumstances in which his clients might prefer the remedy available under section 140B rather than under MCOB, and that was at day 1, page 164, line 8 and following. Now, my learned friend didn't explain that submission or explain why that might even theoretically be the case. But if that's right, and I say if because you've seen that the claim is not pleaded differently in the sense of the release order, so it's not clear why the remedy might be preferable. But if it is, and the claimant's complaint is what the provisions of MCOB provide, because if he's saying that he thinks he can do better, then he's actually criticising that regime. It's not a justification for his construction. And it is, of course, the regime that Parliament intended to regulate the fairness of mortgages. So standing back then with those 4 points in mind, the overarching flaw in the claimant's case is that it's simply a transparent attempt to bring excluded mortgages back into orders under the unfair relationship regime through the back door. And that isn't permissible because the clear purpose viewed textually and contextually of section 140A5 is to exclude regulated mortgages from the court's remedial powers under section 140B, and there is no reason that he identified why section 140A5 should not apply with equal force in cases where the mortgage happens to be related to another credit agreement. He offered no cogent reason for why section 140A5 should be read down in those circumstances. There's no support for that carve-out in the text or in any of the explanatory materials. And it's not clear on his case why it should matter whether the regulated mortgage is a related agreement. And we say there's no good answer to that question. Now, my lord, for the remainder of my submissions, I was proposing to show your lordship the key parts of section 140A. I appreciate you've looked at them. I'll take that quickly. I was then going to address the court on the meaning of in connection with by reference to two cases, and I was then going to return to section 140B to address the parameters of that section. And finally, if the court wants to hear it, I can address you on the legislative history of section 140A5 and why the addendum note argument is flawed. But it may be that I'll be guided by the court on this, because it may be that, as I said, in a sense, even if he was right, it wouldn't matter, given the fact that the regime's been repealed. But in fact, we suggest he's not right, and I can show you why.
I would guess, others may disagree, that you can take the linguistic points quite quickly because we can see those quite readily. Given the emphasis placed on the archaeology, I think you do need to go through the archaeology.
That's absolutely fine, my lord, and I'm ready to do that. So may we just look at section 140A? I think you already have it in front of you. It's the authorities bundle, tab 17. So you see that subsection 1 empowers the court to make an order under section 140B if it determines that the relationship between the creditor and debtor arising out of the agreement or the agreement taken with any related agreement is unfair to the debtor. So what's clear here is that the court is required to determine the fairness of the relationship . The relationship is the one that arises under the credit agreement taken together with any related agreement. And if the relationship is unfair, the court may make an order under section 140B, subject to subsection 5 of 140A, which says an order under section 140B shall not be made in connection with a credit agreement which is an exempt agreement. And it is common ground that a regulated mortgage is an exempt agreement. So you can simply read that as an order under section 140B shall not be made in connection with a regulated mortgage. So that is very stark. And just to give you an example, subparagraph 6 is referring to the COVID scheme. And on my learned friend's case, when we come on to the history, you see that the same exclusionary technique is used in 5 and 6, and yet on my learned friend's case, the COVID agreements would be brought back in by the same mechanism as he suggests these would be. Now, my learned friend's argument in a nutshell is that the prohibition in 5, which he can't get round on the words, quite frankly, can be evaded if rather than starting with the regulated mortgage, one instead says the credit agreement for the purposes of section 140A(1) is the unsecured loan and the regulated mortgage is the related agreement. And I think my Lord Justice Newey put to my learned friend that his argument really put the weight on credit agreement rather than in connection with. But I'm not sure that my learned friend accepted that, but that is the truth of it, really. And the position, though, even if he did put the weight of it on the credit agreement, is that there is nothing in section 140A(5) that draws a distinction between whether the regulated mortgage is the primary credit agreement or the related agreement. So there's no linguistic support for my learned friend's anchoring idea. Put another way, that distinction is irrelevant to the exclusion in the subsection. And the only test in the subsection, as you've seen, is the in connection with test. And if that test is satisfied, the prohibition on making an order under section 140B is absolute. My learned friend's argument also leads to the surprising conclusion that the exclusionary effect of section 140A(5) is dependent on where one arbitrarily begins the analysis, even on exactly the same facts. And we address this point in our skeleton argument at paragraph 59. But in this case, one sees there are two credit agreements for the purposes of this argument, a regulated mortgage contract and an unsecured loan. If the together mortgage is analysed as the credit agreement, so the anchor in my learned friend's terms, and the together unsecured loan is the related agreement, my learned friend accepts that the court cannot make an order under section 140B. But if the very same agreements are analysed the other way round, he says the court can make an order that would otherwise be prohibited. So you get a different answer on the same facts depending on where you start. And so if he had an argument to that effect, one would expect my learned friend to have been able to answer my Lord Justice Baker's question as to why the loan is the anchoring agreement rather than the mortgage. And there wasn't a satisfactory answer to that. And there's no reason, therefore, to suppose that section 140A(5) was intended to work in any such arbitrary way, nor is it suggested that primacy is to be given to the primary agreement when conducting this analysis.
Do you say in any event, on the facts of this case, the mortgage is obviously the primary agreement?
My Lord,
Not relevant to your argument.
I don't need to, so I don't need to make that submission. It seems to me that it is because it's called the together loan because it goes with the mortgage. It does seem to me that there's a pretty good argument that it is, but I don't actually need to make that because the final point is, even if you accepted my learned friend's case about the anchor or non-anchor, he doesn't give in connection with its proper meaning. May I then turn to the meaning of in connection with? And it's obviously trite that these words are to be given their ordinary meaning. And the ordinary meaning of the words connotes a loose or broad degree of connection required to meet the threshold to engage with section 140A(5). And I can show you, as needed, two authorities on that point. The first is the decision of Lord Justice Rick sitting in this court in Campbell and Conoco, and we cite that in paragraph 53 of our skeleton. It appears in the authorities bundle at tab 3. So, my lord, the appeal arose out of an accident on an oil platform in the North Sea. And if you look, my lord, at paragraph 5, which is on page 85, the worker on the platform was injured while carrying out fireproofing work, and the accident and injury were, it quotes, in no way related to that work. The key issue was whether the liability for this injury fell within the terms of an indemnity in the contract for the fireproofing work. And if you look at paragraph 6, the key phrase was arising out of or in connection with the performance or non-performance of the contract, regardless of the cause or reason therefore. You can see that at letter A on page 86. And then if we look at, please, page 88, paragraph 19, this is now the judgment of Lord Justice Ricks. He says, the words throughout the clause are very wide and the connecting links expressed are themselves of increasing with, ending with, the words in connection with, which are widely regarded as being as wide a connecting link as one can commonly come across. And he said there's a need for a connection of some kind, so not a causal connection in this case. That judgment was referred to more recently by the Court of Appeal in the 2024 decision in Celestial Aviation Services, and that is in tab 13 of the authorities bundle, same bundle at the back. And, my lord, in this case, the Court of Appeal was concerned with the interpretation of legislation concerned with sanctions, and the legislation also used the phrase in connection with. And if one goes, please, to page 304, under the heading The Issues at paragraph 8, and this is the judgment of Lady Justice Falk, you see that issue 1 on appeal concerned whether the payment made under the letters of credit were in connection with an arrangement caught by the terms of the sanction. And the relevant legislation is quoted at paragraph 24 on page 307. And if you cast your eye down the various paragraphs, you see that all 3 of the subsections of Regulation 28 use the expression in connection with. And then if one goes on, please, to page 313, paragraph 44, you'll see that the argument on appeal was that the court below had failed to give effect to the ordinary and literal meaning of the words in connection with. And that argument wasn't tied into the particular piece of legislation. And the appeal succeeded at paragraph 49. And what was said was, by the learned judge, was that the purpose of the legislation is of central importance, and it's critical to identify that purpose with care and not to overlook the fundamental point that statutory construction requires an exercise of identifying the meaning of words used in their statutory context. And the judge then went on in paragraph 55. I'm sorry, I should show you that 54, the judge then consistently held that it was important to read the regulation in context. And then in 55, she said the words in connection with are broad, citing Campbell and Conoco. And then she tied it into the words also used. And I would also agree with Unicredit that the words in connection with do not require any form of legal dependence or explain, for example, by reference to principal connection, rather the question is one of factual connection. And you can see at 59 a conclusion that payment under the letters of credit would be in connection with the leases. That is obviously the case in fact. And she went on to say that they were straightforwardly in connection with. Now, I should add that this case has been appealed to the Supreme Court and the appeal was heard in December. But I don't know when it's scheduled to be decided. But one can see, I don't think that's relevant to this point. What one can see is the words in connection with as is tried have a very loose meaning. Of course, they are to be construed in context, and I don't deny that in any way. But in fact, the context supports my position, which is the context of Parliament's intention was to remove regulated mortgages from regulation under the CCA and to put them into a different regime. So on that basis, there's no justification to try and read down the words in connection with. In fact, they are to be given their normal meaning in the loosest sense. The other thing I take from the Celestial case is that the connection is not of anything other than a factual connection. And here, having shown you the pleadings, you can see that the remedy is for repayment of sums due under the mortgage. And it can't, that is in fact connected to the mortgage. If we might then look at section 140B, please, of the Act, which is back in tab 17 of the second authorities bundle, and it's at page 339. And it's important just to see what the orders under the section may do. And the powers appear to be therefore not open-ended. As Lord Leggatt put it in Smith and RBS, which you were shown yesterday, the court must select from the list of options in section 140B1. If you'll note, that was at paragraph 16 of that case, which is in the authorities bundle at tab 11, and it was page 252. If your lordship reads through these remedies, you'll see that they are ones granted by reference either to the credit agreement or the related agreement, with the exceptions of D and G, which are not relevant to the claims in these proceedings, but they're also necessarily connected. So, for example, under A, the court can require repayment of sums paid by virtue of the agreement or any related agreement, but the court can't order payment of compensation or some other general sum. Or under F, the court can alter the terms of the agreement or any related agreement. And we suggest that when one looks at this list, it's obvious how section 140A5 works, because it shows in concrete terms what the court is prohibited from doing. The court can't make orders under section 140B that are concerned with or in connection with a regulated mortgage. So the court cannot order repayment of sums paid under a regulated mortgage. The court can't alter the terms of a regulated mortgage either, because such orders would plainly be in connection with the regulated mortgage. They would necessarily have to refer to the mortgage contract and make provisions in relation to it, which plainly crosses the threshold of having some connection, to use Lord Justice Ricks's expression, or a factual connection, to use Lady Justice Volk's expression. And that's why the learned judge was plainly correct in his conclusion on issue 3, and it was in the order at 2C, and that's the only part of the order challenged by my learned friend on appeal. And we suggest that the conclusion he reached is entirely correct and should be upheld.
Does that really take you on to the archaeology?
It does.
So that's a good moment to break. 2 o'clock.
All rise. Available.
Hot, isn't it?